I started talking yesterday about parental liability and institutional liability for the Gilbert, Queen Creek, East Valley violence that has taken place against our teens. There's been a lot of talk about how the parents of the perpetrators have money and that's why they haven't been prosecuted. Well, the good news when somebody has money is that they can be sued, and there are many ways to hold people accountable. One of those ways is civil liability, and it's remarkably effective at holding people accountable. So let's talk. This person says, talk about the difference between the burden of proof and the civil and criminal cases, and whether the victims have to wait for the criminal cases to be over before filing a civil lawsuit. Happy to talk about it. My name's Billy Tarasio. I'm an Arizona family law attorney. I usually talk about family law, but now we are going to spend some time talking about the attacks that have been happening in the East Valley, and one of which led to the death of a teen, Preston Lord. In a criminal case, the burden of proof is beyond a reasonable doubt. The prosecution has to be so convincing that the jury believes that there is no way that the defendant didn't commit the crimes that he or she is being charged with. It's a very high standard of proof, because if you get convicted of murder, you can go to jail for the rest of your life. You could be subject to capital punishment. It's a very, very high standard of proof. Civil cases, that is not the case. In civil cases, when you sue someone, the question is preponderance of the evidence. The lowest standard, much lower than in criminal cases. Is it more likely than not that what the plaintiff is saying happened actually happened? We sometimes in family law have cases where there's been assault by a husband or a wife against their spouse, and we can't sue for damages in family court, but we can sue in civil court, and that's where we most often see this come up. So in terms of what order should you do it in, well, there's a bunch of factors that should be considered, but there's no hard and fast rule on, do you have to wait for a criminal conviction before you sue civilly? The answer is no. And you have to look at the statute of limitations to make sure that you don't wait too long. So here are some of the considerations when determining whether or not to wait for a criminal trial to be done before you sue civilly. Evidence gathering. So if you can get a criminal conviction, so much evidence is going to be gathered for you, and they will have already met that higher standard of proof, so you can use all of that evidence in your civil case. Number two, Fifth Amendment rights. People do not have to incriminate themselves. So you wouldn't be able to necessarily depose them or get the information that you needed for your civil case if the criminal case wasn't done. So that's definitely a consideration. Public perception and safety. The outcome of your criminal case could impact the public perception and your strategies in the civil case. That's something to think about. And then resource allocations. It could be that right now resources are much more focused on getting a criminal conviction. But because we think that there have been many victims, it's something to think about, whether or not you can sue, whether or not you should sue, whether or not you have the evidence you need, and whether or not these victims getting together and sharing evidence is going to make your case for civil liability stronger.